welcome to our Zoom, the special edition. Although we normally have them on Wednesdays, I had a mix up in the schedule as to when I was supposed to accompany Pops to his appointment. That's tomorrow, so but it's all good. Still got some good news in the wake of what some people may consider bad news. We did get one of our guys had a successful courtroom appearance. And for all the other guys who are getting ready, in fact, there he goes right there. So without further ado, let me go ahead and say this before he jumps on. What's going on? Rick is not an attorney, don't have a license to practice law. I don't practice law. What we do is study law. I tell people what I've learned, how I gathered information. Don't give information as advice to apply to your specific case, but it's general information regarding the law and lawful principles, which, by the way, belongs to the people. Use any information for educational edification only. And if you feel uncomfortable with the information shared, please feel free to go about your way. But if you wish to continue, you may. And all the information here that we may share is for fair use. What's going on, champ? Rick, you there?
Yeah, what up, though, Dawes?
Hey, man, man. Hey, we're all on your time. So the guys came in. I told them that you called me and told me what was going on. I'm like, wow, that's great. So why don't you, if you don't mind, giving everybody a little background on what happened today, or a synopsis of what happened today. It is actually absolutely your day, and we love to see people have good results, and not just some things that people say, but some things that can be proven. So knock it out, man.
Yeah, in regards to today, I had an evidentiary hearing based on Texas Rules of Civil Procedure 106, where I was improperly served. I presented documents in my case within the court's filing um, to prove that I was improperly served. And today was my evidentiary hearing on my special appearance. While in court, just in reviewing the paperwork I submitted alone, the judge honestly had no questions for me. All her questions were directed towards the attorney general in regards to the improper service. I really didn't have to state much other than listen to her say that my case was dismissed. The paperwork spoke for itself. It was just a due diligence, like you always say, apply, apply the rule that you're having a problem with in your case. And so that's what I did. And I received relief from that today with the dismissal. So I just want the fellows to know that it's possible, man, with due diligence and properly following your paperwork, and going inside the courtroom and actually fighting.
Yeah,
There's no such there's no such
exactly.
thing. Yeah, there's no such thing as no magical pamphlet, no magical paperwork. I didn't purchase any paperwork from anybody. I studied, I did my due diligence and applied the rules to the law.
There you go. But you did have to go inside the courtroom, right?
Yes, sir. I had to go inside the court. My first initial meeting was a Zoom meeting, and then once I offered evidence in reference to the improper service, then the case was reset for the evidentiary hearing in person.
Okay. Now I want to go back to some of our previous conversations. Go back to when you said where you said you were when you made the first call. I think because you were part of our very first class too, right?
Yeah, I was. Yeah, I was.
And tell them like you talked to me today when you talked about focusing on what's important and why you're in there.
Yeah, I mean, basically, I just focused on the issue. I, 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 I basically pretty much followed the steps in Iraq as you pretty much explained to us time and time again. What is the issue? What is the rule? You know, uh, Apply the rule and then add your conclusion, and that's basically what I did. And in my case, the issue was the improper service of process. The rule for that in Texas is Texas Rule Civil Procedure 106, which states that in order to acquire per, uh, in order to acquire personal jurisdiction, then the defendant can only be served in one of two ways. That's personally serving the defendant or through registered mail. Anything outside of that, then they must go back into the court and ask or request for a substituted service. And there was no substituted service requested. And in my case, although it was left at the door, there was no substitute service granted by the court, so you had no authority to leave it at the door. You are prescribed by rules of Civil Procedure 106, and as I stated in court, Texas is in strict compliance with civil rules of procedure. So based on that alone, the judge looked at me. She looked at the plaintiff in the case, which was the attorney general, and she asked, "Hey man, did y'all actually follow all the rules in 106?" And the attorney general attempted to make the statement that they made the attempted service at a prior address that I once lived at, and I objected to that. And my objection was that the law requires you to personally serve it on me, not at a prior address in which I've lived. And in fact, the court has had all due diligence. It is up to you guys to serve the papers on the proper location. If there's no due diligence shown, then the court lacks jurisdiction. So that's basically, what I went in court and argued this morning. Like I said, I didn't really have to argue much. The paperwork that I submitted pretty much spoke for itself. I would tell any of the guys, hey man, case text will be your best friend when going into court. Case text will always be your best friend. Like Greg say, a lot of the times when I go into case text, I use the parallel search. And the parallel search just provided everything that I needed in order to provide to the court so that they can come up with a definitive answer.
In that part, even if given some slight instructions or some directions or even viewing a document, doesn't do any good if you don't apply your state's facts and the facts of your case within the whatever you file, whatever your pleading is, correct?
Correct.
And we met how long ago?
About 4 months now.
In 4 months, okay. That's like before football season. You're right. And
yeah.
And tell them
Rick, how long you been on child support prior to meeting Greg? If you don't mind me asking.
Oh man, I've been on child support, bro. I'm 45. I've been on child support every bit of 20 years, 21 years.
God, well, I know that feel good. Excuse. I know it feels.
Yeah, man. I'm not gonna lie to none of y'all fellas, bro. I walked in there, like I told Greg Greg was the first person I called when I left the courtroom, bro. I didn't even call my mama. Greg was the first person I called, and yeah, real talk, straight up, bro. Like I walked in there, bro, a little shaken. It was really my first time in the courtroom proceeding of that atmosphere. Everything else I've ever dealt with has pretty much been criminal matters. So I walked in there not knowing what to expect. But once I got in front of the judge and it was my turn to present the evidence that I had, it was like, man, my chest was stuck out the gloves. I let the hands fly, bro.
It
no
hit different when you
punches,
know the
bro.
rules.
Yeah, it hit different, it hit different. And one thing that I learned after today, like Greg stated, man, he made a valid point, bro. What I did notice today, bro, is when they're on defense, bro, they don't know how to adjust. They don't know how to switch. They don't. Let's just say if they was a right-handed boxer, they don't know how to switch to that southpaw stance to defend themselves, bro. It's
why switch
impossible.
when you've been knocking them out with the right hand for 100 years?
Right. So now they had to defend, and in my case, bro, when they switched to that southpaw stance, I just kept sticking them. They didn't know what to do.
Clean them up.
And so, like I say, man, I was granted the relief I sought. I put in a motion for dismissal, and the judge granted that, bro.
And those are the things that kind of come with the personal conversations. But again, everything that we do I asked you earlier, I said, did you think that the child support basics have been helpful, or I guess you got to combine it with what we've spoken about without being in the classroom. But has it been helpful and goes straight to the point?
Yeah, like I started earlier, man. Just the child support basics within itself has been very helpful because you know, it actually teaches you, where to start, from beginning to end. If you have complications with certain issues within your case, I mean, the classes itself is telling you where to look or what rules to apply to that specific issue. The only change would be implementing your state. I mean, throughout everything that I went over with the whole group, throughout every class, the only difference was that I applied Texas law in my instance because I'm in Texas. That's the only difference. But everything taught in the class is what I use to ultimately defeat them today. I just applied Texas law versus being Florida law where you located or North Carolina, whatever. I'm in Texas. I applied Texas law.
Well, on behalf of everybody who wanted to hear your story, congratulations, and we'll wait to see if they decide to do anything else. And for clarity, how old is the child in question now? How old are they?
He's 15.
He's 15. Okay, intriguing, intriguing. Anybody else got any questions, thoughts, comments, congratulatory?
I got a few. Did you have arrears and was that dismissed as well?
Yeah, the cases the case the entire case itself was dismissed.
Okay. And then
Just
okay.
period.
And
Oh
Because
then
wait,
what happened, the reason it was dismissed because in Texas, you leaving it at the doorstep is considered a substitute service. Well, Texas law requires that before a substitute service can be attempted, you have to show due diligence in at least making an attempted service in person.
That
got it.
that may be applicable in many states because
And
substitute.
I was just going to say that, Greg. I think that is applicable in many states.
I know Florida for sure. I think it was similar.
Right. Well, but Florida
So
initial service of process, the initial complaint has a set of rules because substituted service may sometimes involve an amended complaint, and if you amend the complaint, then you had to have leave of court and all those other rules kind of pop in. But I think a lot of times, I think most of our situations, I may be speaking out of hand because in Florida, I know Rick and Johnny are both in, not you, Rick, but the other Rick and Rick and Johnny are in Florida. Don't you kind of see the same set of issues in all Florida cases, or at least all the cases in y'all's area?
yeah, for sure. I can't remember the rule off the top of the hand, but I know it's one of the rules. If you use like constructive service, what you can ask for is limited. Like you can't even be asking for child support if you're not served by like a sheriff. If you use another alternative to serve, it can only be for certain things, and asking for child support isn't one of them. And that's most of the time I would get served, like just through the mail or some other random way.
That's interesting. Well, I got one more guy in Florida, right? Tyler, you're in Florida, right? Oh, I think he's on here. I can't see.
Yes, I'm on here. Yeah, I'm in
Uh,
Florida,
and
Orlando.
and briefly, real brief, Greg. You know what else I also brought up in court? Is that by Texas law alone, the case was barred by limitation.
Are you more
I don't.
4 years? Did y'all have a 4 year statute of limitation to initiate an action or something like that?
Well, no. Well, by it being a civil matter, the case had to been have once it's filed, it had to have been served within 90 days of its filing, which it was
Okay.
not.
Okay, yeah. Service of a process. Yeah, that's
Yeah.
120. I don't know if Tyler's on here, but his in Massachusetts is 90 days. And they went and did substitute service in Florida. Try to do a enforcement of a foreign judgment that didn't serve them. And I see a lot of these service of process issues. And I think sometimes people waive it by showing up without challenging it and then not going back to argue whether or not that's a foundational issue or fundamental issue. that would demand that the case be dismissed as well for that.
Right, right. Because here in Texas, I mean, well, it's probably everywhere, bro. But I mean, we have a catch-22 out here. Like, if you show up in court, then that's you're granted to the court's jurisdiction. You know, a general appearance is an appearance. If you fail to respond, then it's just the same as an appearance. So, you know, fortunately, I did my paperwork in regards to a special appearance. Rule 126 here in Texas, I did the special appearance, which allowed me to go in court without giving them jurisdiction and plead my case.
Right, because of your first appearance and you didn't waive it specifically. Yeah. But if you waive it, then you get into the merits, and that's another issue. I think we discussed that as well, because I don't think a lot of these cases are involved are based on meritorious determinations. It just kind of like say, hey, you're here, she's broke, or whatever the situation is, and you owe money, and they don't discuss anything specifically that would occasion you having to pay support. So I think that just seems to be considered. What's up, Gary? Hey, that's the guy that actually named me Squid. That's known me for he no couldn't hear you, Gary. You gotta unmute your phone. You know, unmute it, man.
Yeah. I said I've been here the whole time. I've been cutting and listening.
All right, appreciate you stopping by, homie. Yeah, I don't know Gary for 20 some years now, but and he was a part of the development well before I became this grade for sure. So, and he's done some of the same things. In fact, I know he's cutting now because he could be the one to tell you what it's like to get credit whenever like there's a discrepancy in the case, because Gary was granted credit. I don't know if you can hear Gary. How many years credit were you granted once we went back into that case and she had to admit that she had gotten money?
13 years. It was like 17,000, something like that.
Had to give him credit, yeah.
It was really more than that, but they had to, you know, give her a number that said, hey, you either cop out to this or we're gonna have to pay him.
And that ended your support then. And how old was Garius when that happened? You remember?
Teenager.
Teenager? Okay. So again, and that just boiled down to what we didn't know then versus what we learned along the way. And like I say, a lot of this stuff is not so complicated and there's nothing magical about it. But you know, Gary was like one of the original guinea pigs.
I really was. That's to go in there cussing them out.
Hey,
I take credit for being one of them frontline boys. I caught all the bullets and all the stabs. I did that.
Tom Rick, Florida, Orlando Rick, that he knows JT also.
Okay. All right. Yeah, well, James.
I don't know if you know Gary, but yeah. So it was it takes footwork and it takes dedication. I just wanted to do this quick one so we can get a live testimonial from somebody who actually had a case dismissed. If they try to come back, we can deal with it then. But
right.
But you feel a lot better. You don't have your first real match. How do you feel in retrospect, Rick?
Oh man, I feel good, bro. Like I'm ready to get off work and go celebrate and kick my feet up and enjoy this moment, you know, because I know I got a battle ahead of me, man. They really didn't like the way I came in there and just shut everything down. You know, I mean, I had all the other guys that was in courtroom looking at me like, who is this guy? You know, because I walked in and pled my case and walked out. Like, can I be excused? Are we done? She just was like, yeah. You know, and she didn't remand me back to the seat like she did the other guys. So now I know everyone else is wanting to know why I'm being treated differently. Well, it's due diligence, bro. Due diligence, you know, to take the time to read, study the law, and apply the rules to my issue. That's it.
It's all it's like iron sharpening iron and going through it. and again, I'm not surprised that you could do it. I think everybody can do it, and I don't think it takes everybody to be so wholly invested. But other than what your personal resources, and I think we can get it done. I think we have a lot more success. I don't know if is Terrence in here? Not Terrence. Mr. Marcus in here? Okay, you must not know. That's the other guy. That's your guy
Yeah, that's my guy here with me in
yeah.
Austin.
Okay, yeah, that's the guy from Austin. So hopefully he picks this up. And again, I really don't like talking to none of y'all, but if it helps, it's cool. But I think everybody, there's so many people in so many places that have this issue, and a lot of times this issue is not even related to people being deadbeats or not wanting to be involved. It's just involving we just didn't know, and that's unfortunate because the damage is severe. And like I said with G, it's been about 10 years now, right, Gary? That's all been over with, right? If not more than that. Shoot.
Yeah.
Yeah, yeah.
And real quick, bro, like I was telling you earlier when I first got out of court, man, just for the guys, man, while I was sitting there watching the other cases before mine came up, man, I heard a lot of attorneys approaching their defendants. And the one key thing that they was telling them before they got up in front of the judge was, hey, only answer what she asks. Do not offer any other
No kidding.
don't offer any other testimony other than what she asks you. Stick strictly to what you're being asked. I've heard 3, 4 different attorneys mention that this morning. And like I told Greg, when I heard the first attorney say that, all I could think about was Greg, because he's constantly drilling that into our head, bro. Don't offer anything else. If it isn't asked, don't answer it. If it isn't brought up, don't discuss it. Only
right.
offer the information that is asked.
Absolutely.
That's right.
And it was just funny to me. I watched 4 different attorneys all approach their clients stating the same thing before they went before the judge. Like, hey, if she asks you anything, only answer what she asks. Don't offer any other testimony.
Wow. And I guess I don't know if you know because you're not there with them, but were you there long enough to watch anybody else's situation, or you were only there for yours and then you left?
Man, it was there for everybody's situation. There was various situations in the courtroom. I think they pretty much held me to last because mine was a special appearance.
They always do.
Yeah. Yeah.
Yeah. They didn't want anybody else to comprehend. They didn't want nobody asking me where did I learn this secret information from.
They ain't see.
They see that paperwork. They seen that paperwork. They know what's coming.
Yeah. Nothing's a secret. We just happen to try to work within the rules. Because I guess the other question I was going to ask is, did any other attorneys, or did you witness any of the other people? I don't want to say attorneys. I don't want to say nothing disparaging about attorneys. Because I think I do highly recommend that people get an attorney. But did you notice any of them being aggressive with the state in the manner that you were kind of direct with your presentation?
I watched one attorney attempt, and I think that's what kind of shook me for a brief moment, because I watched one attorney attempt in the case where the the 2 parties they were in the middle of the dispute, but they're still living together. One wants the other party out, the other party refuses to leave, and so his attorney tried to get blunt with the judge, the presiding judge, and she shut it down so quick to where I was like, oh man, I'm finna try to remove this from this court immediately. Like it's time for a change of venue just based on her actions. She wasn't really giving nobody an opportunity to present anything. I watched her sentence another guy to 180 days today, unless he was able to pay $1,000. So. And I'm like, bro, if only he would read the law, he would know. Like, bro, they can't just give you 180 days without showing that you're capable of paying. Like, come on, man. But if he don't attend our classes, he wouldn't know.
And he wasn't represented by an attorney?
Yeah, he was represented by an attorney, and an attorney fought to have the 180 days that they wanted to come back. He wanted the attorney was trying to reset the case to give the guy time to come up with the funds or whatnot. And the judge wasn't trying to hear it. She said the case had already been reset twice. So she didn't really give the attorney a chance.
They remanded him to custody?
Yeah, they remanded him to cut 180 days.
Well, that's interesting. You can't say what they can't do. It's whether or not what they did was proper.
Right.
That's interesting. And did the court prove, or did the court did his attorney proffer any information that would have given the court the ability to determine that he had a present ability to pay?
She just basically asked the man why he hadn't made any payments from since 2010, and the guy explained to him that he been in the house, he lost his job in 2010 or whatever due to 2021 due to COVID or something like that, and then after losing his job, he had to have a kidney transplant, so he's been going through dialysis. That's what his attorney offered as evidence as to why he ain't paid. His attorney, his client has been in the hospital. Going through. He had a kidney transplant. Now he's dealing with dialysis. That's pretty much what the attorney offered today. But in lieu of all that information, the judge wasn't trying to hear that, bro. That's why I say I was a little spooked before I got up there. Like I told you when I first called you, like I was like a deer in headlights when I first got up there.
See something real quick. That's a little bit interesting. Y'all see the screen now? What do y'all see?
Parallel.
Find a case that says, yeah, parallel search.
Kind of interesting.
And the guy said, man, he had no prior knowledge. Like the child in this case is 15. In this particular case I'm talking about, the child in this case is 15. He say he had no knowledge of any order out against him or anything. And he's already paying child support on 3 other kids. He had no knowledge of this last order.
You see that? Everybody want to read that in reference, JD? Can y'all see that?
In reference, JD, it states while the trial court has wide discretion in fixing the amount of child support payments, and while each case must stand on its own facts, the determination of the amount must be supported by evidence that the parent obligated for child support is able to pay and can pay the amount specified in the order. Yeah, that's what I was stating to myself. That's why I just said, like, don't they have an obligation to prove that he can make that payment? They weren't trying to hear that, and I don't think the attorney offered that information, or either he just had lack of knowledge.
Did you say he had an attorney?
Well, he probably should have objected to it to put on record in the first place, right?
I'm trying to see because I'm guessing she found the court may not. There you go. Do that. Anybody want to do that one in the Office of the Attorney General?
The court may not find a respondent in contempt of court for failure to pay child support if the respondent appears at the hearing with evidence showing that the respondent is current in the payment of child support as ordered by the court.
We want to see. We don't want that one. So current is the only issue in Texas?
Yeah, Texas got some messed up laws out here, bro. Nigga messing fuck around, move to Florida.
Florida ain't that much better.
Shit.
Here you go. But the obligation to support of a child is viewed as a legal duty, not a debt. Some of the attorney people cares about that. Man. Oh, there you go. Y'all see that? The Texas Family Code provides that a child support obligor may plead an inability to provide support in the amount ordered as an affirmative defense to an allegation of contempt for failure to pay support. The obligor bears the burden of establishing defense of inability to pay. Y'all see that?
He should have brought that doctor's note or something to court, something.
Yeah, but then you start getting into testimony and contradicting testimony. If his testimony is all that the court has to go on, then the question becomes, can the court disregard his testimony when no other facts are provided that would dispute what his statement, right? His testimony is evidence, right?
Right, correct.
And that's not legal advice. I'm just saying. He said he spoke to it.
Basically, you saying he needed you.
No, he needed to, I don't say what he needed. Consequently, it is concluded that contrary to Lopez, the burden to prove contempt for failure to make child support payments previously ordered does not include the obligation to prove beyond a reasonable doubt the ability of the accused. That point is overruled.
Maybe that's because it's the obligor. If you scroll back up, it said it's his
duty.
It's his burden to like maybe just saying it ain't enough. Like you literally have to bring a doctor.
You have to bring some type of proof, right?
Say, yeah, you know what I'm saying? Showing that you can't. This is the reason why you can't work, or this is the reason because you have the burden to do that. So, or you bear the burden. So,
I think the point is if you go in and testify, unless they have evidence contrary to that, because their job is to find the facts.
We ain't read that yet.
Yeah, I can tell you what happened with me.
Oh,
what's that?
All right. When I had went into court on the very first, Greg, the very first letter that they gave me spending my life. When I went to court on that, remember when you was asking me when was the order out for like June 26th? When I went there June 26th, they wanted me to pay like let's say $1,000. I told them I couldn't pay $1,000. I brought a vet bill because I breed dogs, so I brought a vet bill that proved that I just had a C-section and then the amount of puppies I had. And then I let the court know, like, hey, just because these dogs were born, they could catch coccidia, whatever. When I went back to court, they had asked me about the dogs. I had showed them paperwork that the dogs had caught a little disease, and I needed a month, and they waited. So, yeah, I had to show that. Well, I mean, my license was already suspended, but I had to show I was proving to them that I couldn't.
What state you in, Tyler?
Florida.
Oh yeah, I did something like that too, but yeah, it might be different in Texas though.
Yeah, we just read, huh? So we just read, but I don't know. Without going into further detail, because I don't know the guy. Rick, you may see him again. Is to find out.
I'm not.
What's the threshold? What would be the threshold for him to be able to prove that he had no ability to pay? Because there's probably some due process issues that would be tied to, does the guy have a place to stay? There's all these other factors, and again, what's the legal threshold? And I'm kind of surprised that you said he had an attorney, and I'm even more surprised that the attorney wouldn't have raised whether or not the court met the legal threshold, even though it's a third continuance. Did the attorney or did he raise these issues in either the prior two appearances?
But you know what? That goes back to one of the previous classes we had where you had a guy come in and he said he had just got with an attorney and the attorney was willing to help him with his paperwork because the attorney himself didn't know all the required laws. And sometimes that could be the issue. The attorney don't know the law himself sometimes.
Yeah, I'm not going to comment on that part. But if the attorney's representing, I would think that he would have a duty of candor to the client and to the court, not to take the case if he didn't understand the case. I don't want none of y'all stories right now, but I get it. What I'm saying is, if you would think that an attorney in this area would be well enough versed with the law to make a to understand what the defenses could be.
Well, no, Greg, because think about your boy Chop. Not Chop, but your boy from the show. What's his name? One that kicked his feet up on the table.
Come on, Tiger.
Yeah, Tiger had an attorney. What he had to do with that attorney? Get rid of him because he wasn't representing him in the fashion that would help his case.
Okay.
And kind of what I've learned too with attorneys, because it's you in your life, you still want them to follow the path that you want to go down. And you know, originally I was working with an attorney with my case, and then this was when Greg put me on a little more information, and it was behind giving out mandatory disclosure, where the attorney was advising me to provide the judge mandatory information on all my financial documents based on I forget the specific code language.
Hell
but
no.
but exactly, that's what Greg told me. Hell no.
Yeah.
And every single attorney that I talked to previously, they were like, well, yeah, it's mandatory.
My 12.285. I don't tell anybody.
Yes. And I did not provide it, and the judge ultimately dismissed my case. Now, if they would have got a hold of that information, it would have been really bad for me. So I still say, if you do use an attorney, you still want to advise them just based on information that you read or come across through these classes. Advise the attorney of that information.
Yeah,
some of us be feeling like that's why you get the attorney, for that information. That's the whole point of getting the attorney.
Yeah.
I would say I have nothing disparaging to say about attorneys and all and the views.
Hey, man, I'm just glad we came across Greg, man. I'm just glad we came across
Hey,
the
real
information.
talk, man. Hey, real talk.
Hey, there's something to think about. Because I've been there, this done happened to me twice. And you can have a good attorney that's not good at arguing. Like, when it comes to pushing that paperwork, they could be the best. But when it comes to being in a live argument and then exactly what he just said, the pressure, because you got to think, we go in there, we ready for whatever. Now you talking about a man who's fighting for another man that he still got to look in the face and go to jail. Now your heart start pumping, you start sweating. Man, that's pressure, bro. That's real deal pressure now.
That's what they get paid for, man. That's why they get all them hours. That's why they get paid so much, man. They supposed to be ready for that type of stuff. Yeah, but it kind of go back to what Greg say. Ain't nobody supposed to know your case better than you.
You.
And you supposed to know. Like, at the end of the day, that's just what it come down to. You got to know your situation better than the attorney.
I agree.
No, I'll stand by that, because sometimes it's not about the attorney. Sometimes I'll say this in defense of attorneys. Sometimes we're not good at lying, and you take that however a person wants to. But I get the point on both sides. But again, I just would highly recommend that people really spend the time to learn your case. And again, I'm just happy for you, Rick, that you got the relief you were seeking, because there's a couple other guys that have cases coming up pretty soon, or have hearings coming up pretty soon. So it's good to hear.
I got one on December the 4th, so y'all stay tuned.
December 4th, okay.
December the 4th, I got one. I'll be honest with you, I was one that was looking for an attorney, and I'm gonna be honest with you, man. When I gave him the paperwork that we sat and we put together, that Greg drew up, man, my price went from $3,500 to $1,000. And I'm talking about, like, that's why I wasn't in at 3 o'clock, because I'm meeting this attorney, bashing to him because the price just went from $3,500 to $1,000, because we brought him all of the information that he knew. We know the case 100%, all the way in, all the way out. So I agree with that too. You have to know your case And I'm gonna go a little bit deeper. Before you even sit down with the attorney, have all of your facts. That makes a difference.
Right.
If I can send you, if I can email you, if I can, like, this is exactly what I did, right? I started sending PDFs. They're like, oh, what's this? These are the facts. I need an attorney for December the 4th. This what's up. Now they're looking and they're like, well, hold on. All I got to do is argue this motion. Yeah. Oh, that's 1,000. That's what they told me. Before, knowing the facts, knowing the argument, oh, you don't got to do the research. Oh, here it is. And that's going to help you out, man. That's what's going to help you out. And
I agree.
I tell you, man, I hear Greg up every day like, oh, I talked to this attorney. Oh, I talked to that attorney. And it would be nothing. It's completely different when you got all your facts. And that motion written up. And then you tell them, no, look, all I need you to do is go do the motion. I'm going to have the court reporter. I'm going to have all this. Man, that's like, oh, what he said, man, you could be a good client or you could be a bad client. Or you could be the client telling the attorney, hey, go say this. Your ass ain't going to be getting no 180 days in jail. I bet that.
That bothers my spirit from here in Florida. But well, I'm glad I'm glad. I want you to enjoy your victory, Rick, and I appreciate you sharing that with the guys here, because I know you called me. I didn't know what it was about, and I forgot that you had a hearing today. I have other things on my mind right now, but I'm glad that we got it that way. And again, we'll pick it back up on Saturday. We'll do our barbershop talk. We got our last segment of child support basics. I guess it's called season 1. Our 10th episode will be Saturday. We'll talk more about paperwork. And again, if anybody has anything that we need to cover, definitely let us know or let me know, and we'll try to delve into it. With that being said, does anybody else have any thoughts, comments, or what have you?
Yeah, real quick, Greg, just to let the fellas know, man, that supplemental authority that we discussed, I want to say about a week ago, man, that's a real important piece of paperwork, man.
Yeah.
That's a real important piece of paperwork.
Absolutely it is. And again, and echoing what Terrence just said, everybody's happy for you, bro. But you stay with it and dealt with the brashness, with the abuse that comes with taking these kind of classes.
Yeah, man, I got a lot of yelling at just to get to this point, So yeah, I'm enjoying, man, and I appreciate you and the time you spend with us and informing us, on the do's and don'ts when dealing with these people.
I can only share my experiences, and if my experiences can help other people get relief, then hey, so be it. But hey, appreciate everybody for stopping by for this impromptu meeting. I guess it was on our same day, just a little bit later. No comments. Anybody have anything else they want me to address really quickly, or anything at all before I get out of here?
Hey, Greg, what about that paperwork? The picture I sent you earlier.
And what was it about?
About going to court.
Okay, so you have a question?
Just like, how do I supposed to respond to that?
Can't really tell you that. You have a question?
How would you respond to that?
All right.
If somebody else about to get you, yeah. If it were me, I would. You say you can't, and according to you can't make it. I would, if it were me, I'd reach out to the JA, which is the judge's assistant, or I would file a motion for permission to attend telephonically. If it were me, you can't make it. You can't make it. And so long as you get notice.
Like I said, they told me to pay $1,900 just to be able to appear on a Zoom.
Who is they?
The judge assistant.
The judge's assistant said you had to pay $1,900 to ask for a telephonic hearing.
Bullshit.
Yeah, that's BS.
Yeah, that's bullshit, bro.
I've asked the judge several times. I got a little document, I could send to you that describes everything, saying, hey, here's the reason why, blah, blah, blah. I'm asking for a telephone conference or Zoom. It's absolutely free.
I definitely appreciate that if you can.
There you go. Just we'll get that over to you. But yeah, because you're in one state and you can't be in another state, from my understanding, right?
Yeah, I'm in Ohio and the case is in Georgia.
You just can't make it, right?
No, I can't make it.
Okay. State the reason. If it were me, I just would state the reasons why. Not even that complicated.
I know that I did all that, but they just said like I said, to do that, you got to pay $1,900 to.
Yes. If it were me, I would never ask the devil how to save my soul.
I get that.
And I would look for the rule. And what state you say it's in Georgia?
Yes, in Georgia.
Let's see. What do y'all see?
See the Google screen.
No words.
We see you typing in how to request a telephone hearing in Georgia or whatever.
Anybody want to read that for him? In fact, why don't you read that for us, Will?
To request a telephonic hearing. To request a telephonic hearing in Georgia Henry County Child Support, you can contact the Division of Child Support Services Communication Center. And specifically that you want to request a telephonic hearing for your child support case in Henry County. That's the thing. I'm assuming where it was for a child support case. Like I said, I was locked up on the warrant.
Hey.
So
How about this?
Just contact that number.
Yeah, y'all get on here. I tell you, I'm not a priest. I'm not the Pope. And I'm not us. You ain't give me no confession, man. Just figure out the rule. What's your issue? Have a hearing. That in Georgia and you're in Ohio and can't make it. Fine with the rule.
Okay. I got it.
All right. Appreciate you. And if I don't know if he has it on him right now, but he sticks it into the chat, I believe you can pull it over from wherever you are.
All right. I'm gonna put it in there right now. It's a Word document. Can I put a Word document in here?
In
the chat?
Or you can just put your email in there and I can just
all right.
I'll put my email in.
Yeah. I'll send it to you right now.
All right.
Yeah, it seems to be pretty self-explanatory, and then you can always say let's see if we can find an image of one here somewhere.
Yeah, and just other information for others. So Chat GPT is artificial intelligence. Basically, you can ask it to write you a motion, and it will write you a motion for whatever you're trying to do. So I'll encourage people to go out there and check out Chat GPT. I use it probably every day.
So I'm a software programmer, and I will tell you this: before you use Chat GPT, know what the rules that you're trying to apply, because Chat GPT can come up with what we call hallucinations, meaning it makes shit up. And you're not going to know that until someone's laughing at you in court. Well, at least you don't want to know that until that point. I mean, before that point. So just be cautious how you use it.
The name is right there. Are y'all watching? Y'all still see the screen, right?
Yep, that's where I went to. I went to that.
Listen, hearing request.
That's why I just didn't know which one I'm supposed to use for that.
Yeah. Then I would just I just get a standard form and I would just do it. Well, I don't use forms anyway.
Mm-hmm.
But I would just look at a standard filing and then I would just craft it to do what I'm pretty sure what Rick is just Tom's getting ready to send you. You just got an
Okay.
idea of the form, the style of a case, the style of a draft. That's what I do. Yeah,
Okay.
13th. I know how that is. But I don't know why this wouldn't work, even though this is in Florida. See that? So if I guess if it were me, see that?
Yeah,
Then what would you change?
they're right there to Henry County, Georgia.
Yeah, my bag is. Yeah. There you go.
Okay.
Yeah, William, I just sent you the document too. It's basically the same format Greg is showing on the screen.
Good then. Here, there you go.
Okay.
It's in Word, so you're good to go. There you go. Yeah,
That'll work. I'll get that going here in a minute.
help, man. All right. Anybody else? Hey, all right. Well, once again, congratulations, Rick, and as always, imparting. Sometimes it's not about right or wrong. More importantly, it's about clarity. You never reach resolution if you're not willing to engage in honest dialogue, even if that dialogue with yourself. Take time to hug the person you love and love the person you hug. On behalf of GDNAPSC Attorney Pro Se Consultants, I'm Greg Doss, and Gary knows me also as the infamous DJ Squid. I'm saying peace, chicken grease. I'll see y'all Saturday morning. I'm out.
Hey Greg, I do want to say congratulations to Rick, man. I was listening in, but I'm at work right now, so
Oh,
all
okay.
right. Congratulations, Rick.
Congrats.
Appreciate it, bro.
Congrats.
All right.
All right. Peace.